I'd like to welcome you to a brief conversation we're going to have with Perry Nardi. Perry, you're going to explain yourself a little bit to the group here, and I'd like to welcome everyone. We're going to do some bankruptcy conversations today. A lot of times we're covering injury-related topics, but I know it's an interest of mine to try and gain knowledge in those other fields of study that maybe I don't focus on. But I know a lot of questions come up. We get calls at the office all the time about what's the next step for somebody if they're looking at an option after an accident, after an injury, it's affected the family in a big way. Is bankruptcy even a discussion we can have? So I thought no one better than someone who's been focused on this field of practice for years, tons of knowledge. So I'm going to let Perry introduce himself a little bit and tell us a little bit starter of how you got started into bankruptcy field, and then we'll hit some questions.
Sure.
Okay.
Thanks for having me.
Yes.
My practice is up in Maitland, and it's Nardi and Nardi, which I was originally partnered with my wife,
Okay.
who is now a magistrate in Seminole County. Fantastic. And so I'm on my own, and I practice personal injury and bankruptcy. And our office is in Maitland, and for bankruptcy, we do a lot of virtual. So you don't have to be in Maitland to get representation in Maitland.
Right.
And bankruptcy is federal court, and the federal courthouse is downtown. Although currently, most bankruptcy clients do not have to go there. They attend the hearing that is required virtually. So that happened during COVID, and they just never stopped it.
Right.
So bankruptcy, most people don't want to file bankruptcy. Yeah. And I'd say that 95% of my clients, it's the last thing in the world that they wanted to do.
Sure.
And it's understandable. There was a lot of stigma attached in their heads to bankruptcy. But to be honest, there shouldn't be. A bankruptcy statute is there to give people a second chance financially, so they're not burdened.
And essentially, what is bankruptcy? I know we use the word bankruptcy, and we may know it, but what is it?
Bankruptcy is a process that you get your discharge of all of your consumer debts. Now, there's a difference between secured debt and unsecured debt, and when you file bankruptcy, you're primarily getting rid of your unsecured debt. Secured debt would be your car and your house. Most people want to keep both of those, and there's a process that allows you to do that through the bankruptcy process. So, a lot of people are worried about, am I going to lose your car? Well, that's not necessarily a question that could be answered yes or no. It depends on the circumstances, whether there's equity in the car, et cetera. But bankruptcy being federal law, the feds gave the states the right to implement how the statute was going to be applied. So the state of Florida's bankruptcy and how it is applied in the state of Florida is different, let's say, than Georgia or Arizona or some other state.
So federal law applies, but each state has their own variation of it?
Correct.
Yeah.
Correct. And it primarily is applied in what we call exemptions, because once you petition for bankruptcy, everything that you have, the glasses on your nose, your hearing aids, everything, every piece of property you have, real or personal, becomes part of the bankruptcy estate, which means that the feds basically can take it, okay? I mean, it's part of the estate, so everything is included. Now, what can I protect and keep from them? Basically keep from your creditors, because what would happen if I can't protect it, if I can't protect the property, real or personal, it goes to the bankruptcy trustee, and his job is to collect and sell those items, real or personal, and to have those items distributed to the various creditors that the individual may have.
Okay. So if we back up a little bit, we got a way to discharge debt. Maybe we've gotten overburdened with how much we owe on a monthly basis.
Absolutely correct. Yeah. And that, and again, people blame themselves, but hey, inflation, who knew about inflation?
Yeah.
Who knew about all of the, if you get ill, and you're subject, you can't work, you get changed jobs, you lose a job. There are a myriad of things that people go through, and it's normal. And that's what people need to understand. It's normal. It's not necessarily you. You could have, you did the best you can. They keep upping the interest rates. Okay, when you bought the item, it was 6% interest. Now it's 18% interest. The math kind of all of a sudden explodes. And if you're on a fixed income, it's difficult to manage that debt. And then you get in a situation where it just becomes overwhelming. And then what you're doing is you're paying the minimum amount just to keep the debt going. Or you're using another credit card to pay off this credit card. And that's the sign of things are probably getting out of hand. And maybe we need to have a discussion with somebody and think about, the process of bankruptcy.
Got it. Do you have to give an explanation to the trustee?
Some of the trustees, there's a process, and again, it's no longer in person, or currently not in person, where you meet with the bankruptcy trustee. I'm there, representing you, and some. Well, I can only think of one of the trustees, and he wants something very, very short. He doesn't want to hear even a paragraph of what happened. Basically, if you say, I got ill and missed time from work, whatever, if it's small, and then you're done. He doesn't go any further into it.
Gotcha.
But
it isn't. You're not going to get approved because your story didn't meet up to standards.
And there's not enough time because guess what? There are a lot of people that have to use the process. And so going through the process, and again, people are somewhat hesitant, but believe me, there are people going through the process, and we don't have the time to hear the whole story. I have time to hear the story, but the bankruptcy trustee does not.
Okay. So let's back up a little bit. I'm trying to think of the person who's sitting out there going, okay, I've gotten behind on my bills. I'm looking at a podcast that I wanted to find more information about bankruptcy and what is involved. What's the initial process like? Make a phone call to your office?
Sure. You can go to my website, and there's all sorts of information regarding.
What's your website address?
NardyNardy.com. NardyNardy.com.
Okay. NardyandNardy.com.
NardyandNardy.com.
Okay.
And the
what do I find on the website?
You'll find all sorts of basic bankruptcy information regarding the two various chapters that are available through bankruptcy.
And
we haven't talked about that yet.
Okay, gotcha.
Okay. The most common form of bankruptcy is what's called Chapter 7. It's Chapter 7 of the Federal Bankruptcy Code. And that has to do with an individual who is trying to discharge their debts. And through the Chapter 7 process, you discharge all of your debt. Okay. Now, in the state of Florida, the people that decided how to implement the federal statute chose to give a big break to homeowners in the state. So if you own a home and you have basically almost $1 million worth of equity in the home, your creditors can't get it. And they can't get it through the bankruptcy process either, because I can protect it. Okay? Now, if it's personal property, that's the switch. That's the switch. The deal was we give you a big break on real property, but not so much on personal property. So if you have a lot of personal property, then we have to get creative on how we can protect it, because the law does not give us a lot to work with. The way it's implemented is they look at the actual cash value of your item, whether it be, furniture or guns, tools, whatever,
jewelry,
etc. It's cash value, which be the value if you tried to sell it. Basically, Craigslist value is what I always try to. It's an easy way to implement. Is if you have something, go look on Craigslist and see what you can get it for, and that's probably what it's worth. Okay, a lot of people. That's one of the things that a lot of people do. They overvalue what the item is. They have a personal relationship with it.
Yeah.
Who knows how they got it? They've had it for years, whatever, and they think it's worth more than it really is.
Yeah.
But that's how the court or the chapter takes a look at that, is through the value prior to the bankruptcy petition being filed.
Okay. So on your website, we can go. Is there information about Chapter 7?
There's Chapter 7, and then there's Chapter 13.
Okay.
Well, for one thing, another factor in Chapter 7 is that you have to qualify for it. They don't let people that make too much money go through a Chapter 7.
Okay.
So, and the way they utilize that and implement that is what's called a means test, which is a very complicated federal implementation of what the average person is making regionally, and they take into account all sorts of statistics. And to be honest with you, I need a software program to figure it out to tell me whether you qualify or not. But generally speaking, currently it's around $36,000. If you make that, maybe it's up to even 40. You have to.
Gotcha.
Okay. But the idea is if you make that or less, you automatically qualify for a Chapter 7. Okay. Now, if you make more than that, and I've had clients who made six figures that I got through Chapter 7. So don't take that 40 grand or 36 grand or whatever as I can't do it, I won't qualify. No, that's not true.
Gotcha.
It's just that it takes a little bit more creative effort, and we'll have to take a look and see if we can. Now, not everybody that makes six figures may make it through. Circumstances dictate whether you would make it or not, but I have gotten people with six figures through.
Okay. And is this a household? So if it's a husband and wife and they make...
Well, it depends on who's filing. And again, that decision may, whether you want to file jointly or individually, that is something that needs to be discussed. If we don't necessarily... There are circumstances where you want to file jointly, and there are circumstances where you don't have to. Right. So that's something that's requires a little bit more information to make a classification. Now, through Chapter 7, once you qualify, it's a process that it takes about 4 months to get from beginning to end.
I'm sorry, go back again. What?
Yeah, from the date of petition.
Okay, date of petition.
Date of petition until the end of the process it's about 4 months. Okay. Through a Chapter 7, assuming you qualify and assuming there's no continuances, etc.
Sure. So let's go a common circumstance you'll see. If you can give me that kind of case, someone has credit card debt, they have the rent they're paying, they have their car payments, and they've all gotten too overburdensome. They've been without the job for off and on for a few months. They've got the kids, they've got cell phone bills, they've got food to put on the table, and they're like, okay, this is an option for me, Perry. I went on your website, I found out about bankruptcy. Now I'm going to make a phone call to you and speak to your assistant. We're going to sign up some forms online, or am I going to come meet with you?
Yes.
What's that
no,
process?
we don't have. You don't have to come in. What the process is you give us a call. We set up an appointment that's mutually convenient for both of us, and over the phone or Zoom or whatever your preference is, I ask a series of questions. It's my bankruptcy intake information sheet. And based on the information provided, I can provide you right then and there with, whether you should file bankruptcy, because there are times when I will advise an individual not to file bankruptcy. It's not in their best interest at the time. Or secondly, you come in, and due to the circumstances that you have, to protect as much as we can, we may delay the filing of the bankruptcy. I mean, I'll take a retainer to represent you right away for, $500 to start, and then at that point, we're just waiting for the time period to maximize saving my clients so they keep as much as possible. Okay. And then once we're paid and the ducks are in a row, we go. And then from that point, it's a 4-month period of time.
Okay. File the petition, and you'll take care of all that?
Oh, yeah, we take care of once you retain us, then what happens is I give you what I call your homework, okay, which is a packet of information. And basically what is your responsibility or the client's responsibility is to fill out the information sheet regarding, what you owe, who you owe it to, if you have credit cards, who they are, account numbers, stuff like that. It's not brain surgery, but it's kind of a pain. Okay, but it has to be done because we have to disclose all that information in the petition, and then during the process, we'll have to be in front of a bankruptcy trustee who will inquire about the information that we've provided.
Okay. And that's what you're looking to discharge or eliminate or get rid of.
Correct.
Is all that stuff you filled out.
All the stuff that we filled out.
It's important to have, the account numbers and the amount
It
outstanding.
helps,
all that
but
stuff,
we'll also do a credit check.
Okay.
And try to pull as much as we can up because we don't want anything to people
the
move. They forget. I mean, we could have debts that are years old that are still out there that no one's really trying to collect, but it's out there. I want to catch it anyhow.
Yeah.
And totally clear up everything.
Yeah. Okay. And during the 4 months, we've updated some documents, and we're waiting on the court at that time to give you a date.
Once we petition, there is usually a 30 to 40-day process in which we wait for what's called the Chapter 341 meeting, okay, which is a meeting of creditors. And that's when your creditors get an opportunity to basically inquire about your debt with them, and they get to ask questions. Now, today...
All at one time?
All at one time.
And will you be present?
I'm there.
And the client there also?
Yes.
Or just, okay.
Yeah. But here's the thing.
Yeah.
In today's bankruptcy, none of the creditors show up.
Right?
Okay, it's
so
just
Discover
not
Card, Bank of America.
They're not coming. They're
okay.
not coming. Now, the only person back in the day that used to come was Sears. Because Sears, if you bought something through Sears, like an appliance, that agreement, okay, they financed it.
Yeah.
That agreement gave them an interest in your item, a security interest. Just like if you bought a car, okay? Yeah. So let's say you bought furniture, appliance, whatever, you go through bankruptcy, Sears would be there asking, well, where is it and what do you want to do? You want to keep it or not and that sort of thing. Yeah. So if any of your creditors have a security interest in your items, they may want to know if you still owe on the item, whether you want to keep it, et cetera. But the thing is, and the good part is if you bought something on credit and you bought it for, let's say, $5,000 2 years ago, and it's used now, okay, it's now, and you still owe $3,000 on it because of interest, finance charges, et cetera, we can bring the debt down to what its current value is if you want to keep it.
Okay.
And if you don't, we tell them, hey, come pick it up. We don't want it.
Yeah.
All right? And then they may go, well, we don't want it either, so keep it, or they may come and pick it up. But it's your call.
Gotcha.
It's your call.
So it could be some, you went to one of the furniture stores and bought dining room tables and family room and bedroom suite, and it's $5,000, they can say. But I don't want to owe you $3,000 anymore. Can we mark this down to what the actual value is, $1,000?
Correct, and that's what happens. And now we're paying only $1,000, and the interest rate, depending on what it was, if it was an exorbitant, which it tends to be, we get that reduced as well and get a nice payment, a lower payment. Because the whole idea is to give you a fresh start. You don't want to, be burdened, even though you get rid of some debt, you're still burdened by other debt,
Yeah. Right.
So we don't want that.
Okay. So meeting your creditors 30 days in, approximately, somewhere in that range. What are we doing the next 3 months?
Well, there's 2 online courses that are taken. One, they're in credit management. They're required by law. I advise my clients to take one before we petition and one after our meeting with the bankruptcy trustee, the 341 meeting. And then basically it's just a time thing. Gotcha. Nothing really is happening except
I'm not
the
having
required
a deposition.
time.
I'm not
nothing.
going to trial.
No, in fact, bankruptcy is primarily pre-petition.
Okay.
You can win the lottery the day after you file your petition, and they can't get it.
Is that right?
Okay.
Wow.
So everything is pre-petition.
Gotcha.
It's just making sure that all our ducks in a row.
Gotcha. And we've gotten a total dollar figure that's some of it reduced, some of our outstanding debt.
Only if you want to keep
creditors.
it.
Right.
Only
if I want to keep it. What if I don't want to keep it? I've got the
every contract, executory contract that you have. For instance, let's say you have a water softener or something that you purchased or some other long-term.
The furniture example.
All contracts are null and void.
Okay.
Okay. So at that point, it comes down to whether you want, for one thing, you get the choice: do you want to keep it or not? If you keep it, you obviously have to continue to pay for it.
Right.
And this usually comes up primarily with automobiles. Okay. Some people are upside down on automobiles, which is the preferable way to go. If you think you're doing yourself a favor by paying off, and you're thinking about bankruptcy, and you think yourself you're doing a favor by paying off your car loan, no, not a good thing to do. Because if I can't protect it, that's an asset that is easily disposed of by the trustee, okay? So he can sell it, liquidate it, and then divvy it up to the creditors on a pro rata basis.
Yeah.
And so we don't want to give them that.
Yeah.
Okay?
Gotcha.
If you're upside down, no problem. And that means that the debt is greater than the value of the car. Okay? But what's going on? The car market is, I don't know, it's kind of...
You owe more than the worth of the car, right?
Correct.
Okay.
But the car...
And I owe more on the furniture than it's worth.
Correct.
I owe more on the water softener than it's worth. And each of these have payments each month.
Correct.
So if I want to get rid of them, I can say, hey, take the furniture, and now I no longer owe you the $3,000 or the $1,000 it's reduced to. And then with the car, here, trustee. Now, does the furniture store come physically come pick it up? Do I drop it off?
No, you don't have to do anything. It's not yours anymore.
Right.
Okay, come get it.
Okay.
Okay, come get it. You're not doing nothing except give them access to
all right. And you let the trustee know, hey, you can chalk this one off, check it off the list.
Trust. Because if there's
and
a
is that part of that
the trustee necessarily doesn't really care because there's a security interest in the item by whoever owns or has a security interest. The trustee doesn't have a claim to it. The original security owner does. So the furniture store has first dibs on that.
Okay. Gotcha. So let's go the car example, 'cause that's probably real common.
That is very common.
Okay, so what happens? What's the physical event? I give my interest, the title, to the bank that I owe the car to.
If you're saying if you're giving up the vehicle,
right.
Yeah, here's the case. Basically, you notify the creditor, okay, and I tell listen, during my initial interview, if you're telling me, look, because you have 2 or 3 cars, maybe.
Correct.
Everybody usually needs at least one.
Right. Get to work. Right.
But if you have a motorcycle, car, another one that you're paying on, and you're just, and when you think about it, it's not just the car, it's the insurance, it's the maintenance, it's the fuel, etc. It all adds up. And once you look at it that way and you say, really, I'd rather, I could use that money elsewhere. Then we, give them a call, give up whoever owns the note, call, I'm filing bankruptcy, here's the keys, and they'll make arrangements to come pick it up.
Okay. And let's say you owed $8,000, but the car was only worth $5,000. What happens to that other $3,000 does the creditor go, hey, you guys still owe me $3,000.
That's what bankruptcy for. It discharges that.
Yeah.
You come out clean. You owe nothing.
Gotcha. So I'm making less than $40,000.
Right.
Got a lot of debt
Right.
on my table, and it's keep me up at night. Can't focus on it. And we've looked into it, said maybe bankruptcy is an option. I don't know what that means. You're going to give them the explanation, just like you're doing here. Let me look at your individual circumstances. Let's write down all your debts. We now know why your payments are so high, but yet, your income still can't match and pay it all. And file our forms. We do our initial filing. We wait that 4 months. We did that 30 days. Now we're 4 months in. What's it look like? What's the 4-month payoff, or what's the event that occurs?
Well, you get a notice of discharge from the bankruptcy court.
Okay.
And
do we have a hearing? Is it an hour long? Is it 2 hours?
It comes automatically. I send it to you. It comes to me, and I send it to you, and I tell you to keep it because invariably somebody may come out of the woodwork that the client forgot about or whatever, and then you can waive that discharge up and say, sorry, but you're misinformed. I don't owe you anything.
Right. Okay. Somebody the one I get inquiries about from time to time is someone will go, hey, apparently my debt back, 5 years ago, whenever I filed bankruptcy, was sold to this other company, or they bought it, and now they're following up.
See, that happens a lot.
Right.
I mean, mortgages, debts, they get bought by, these these debt collectors.
Yes.
And they're looking, it's a numbers game with them.
Yeah.
And so the way they make money is they buy the debt for a penny on a dollar. And so anything above that is profit to them. And they have banks of people trying to annoy you to collect, get you to pay anything.
Right.
Because it goes into their pocket. And I'm not a big fan of those people. Sure. They not only are annoying, they can be, and there's federal laws to protect people from the annoyance. I suggest that if you're getting harassed by a debt collector, find out who they are, where they're located, and tell them you're going to send them a check, find out where it is, and then send them a letter to cease and desist, certified mail. Good. And then if they contact you after you can prove you sent to them, every time they try to collect from you, it'll be $500 fine on them. Wow. So that's how to, a little bit of advice on how to deal with, because I find that really offensive. Yeah. And not only that, what they'll go and contact your relatives pretending they don't know where you are, just to let your relatives then provide the thumb on you. So it's
call work, call.
Absolutely.
Yeah.
You're not allowed to. All they can do is call work. So then someone from HR or whatever calls you and say, I got a call from somebody. Yeah. And all of a sudden, boom, and you're thinking, oh, now I'm not going to get that promotion. I'm not, so and so knows my business. Blah blah blah. So,
okay. Yeah. All right. So far, that is this Chapter 7. That's
process, Chapter 7.
Right? What's the would you say the odds or percentages that someone Chapter 7's an option versus you're going to discuss Chapter 13?
I'm going to discuss Chapter 13. Well, Chapter 13 is for people that don't qualify for a Chapter 7 because they make too much money. Okay. Or B, or a combination, have too much stuff that is property that I can't protect, yet they want to keep.
Okay.
So it's feasible that if you have, let's say you were, an antique or a painting or something that came down that is worth some serious money. Like I said, it becomes part of the bankruptcy estate, and if it's worth more than I can protect, we have to disclose it. We can't keep it. The only way to keep it is to file a Chapter 13, and a Chapter 13 lets you keep it. The deal with the Chapter 13 is we'll still let you file bankruptcy.
Yeah.
But here's the but. The but is you have to pay back a portion of your unsecured debt over a period of time.
Oh, okay.
Okay, we'll give you
So the Chapter 7, I'm getting rid of all unsecured debt.
in 4 months.
Yeah, 4 months.
In 4 months,
Right.
Okay, a Chapter 13 can take 5 years.
Yeah.
Okay,
Wow.
if you need the time to pay off, usually the general rule is around 25% of your unsecured debt over a 5-year period of time.
Okay.
But you have
Like
to
you're
have
on a
the
payment-
income.
You're on a payment plan.
Yeah, you're on a
Essentially.
payment plan. And basically what you end up doing is you end up making your payment to the Chapter 13 bankruptcy trustee, and they make the payments.
Okay.
Okay,
Gotcha.
so my process is basically
Yeah.
to set up, that type of an arrangement based
Yeah.
on budget constraints, et cetera, and also meeting the requirements of paying back the unsecured debt
Yeah.
for that 5-year period of time.
I remember not being in this field. I remember it seemed like it was pre-COVID. There was a debt consolidation became a real popular option online or in the television commercials was always discussing debt consolidation.
I'm not a big fan of debt consolidation.
Is that essentially they were trying to?
Well, a lot of the
Tell me
debt
about it.
consolidation, it's still going on, by the way, and it's starting to rear its ugly head again because when the economy starts to dip
Yep.
and people start to have issues, maybe the jobs go down, whatever, they start to come back up again. And they're basically, a lot of them are owned by the creditors themselves, the banks. And this is a way, and what they do is they don't guarantee anything. They collect their fee up front. So if you're making I don't know, you're paying them $300-500 whatever to help you, and then they take your money, and you end up realizing they're not doing anything.
Right.
Well, I'm telling you, if you go through bankruptcy, I am guaranteeing you,
Yes.
you're out. You're getting rid of your debt.
Right.
So, I mean, again, but people don't want to file bankruptcy. They want to do what's right, and they think that by going through paying something, but the problem is it doesn't do it.
Yeah.
Doesn't
get
do it.
any of that principal doesn't.
No,
go down.
in the
Yeah,
principle,
you're
you never, with the fees and the interest, you
Right.
just never get to it.
Yeah.
And so I give them a lot of credit in the world for having that mentality to want to pay off that debt. But from a practical perspective, it's just not a good decision.
to get that clean start.
Correct.
That bankruptcy allows you to have.
And okay, then people go, well, then where's my credit? Well, let me tell you something. If you're thinking about bankruptcy, your credit's probably already
Oh, correct.
marginal.
Yes.
Okay, or if you're one payment 30 days away from having it take a nosedive.
Yeah.
The truth is you can't file bankruptcy about 3 times in your life and 8 years between each bankruptcy.
Okay.
Okay, so when you file, okay, somebody that gives you credit after you petition, after you're discharged, all right, they're going to get their money.
Yeah.
Okay, you are an excellent credit risk after petitioning for bankruptcy because they're going to get their money.
You
But
can't
what you're
wipe
going
it
to,
away.
where you're
Right.
going to get nailed and where it's bad is they're going to charge you a great deal of interest until you reestablish that credit rating. And how do you do that?
Yeah.
Real simple. Get a prepaid credit card if you have to. If not, if you do get some nominal credit, buy a pack of cigarettes, box of candy, whatever, every 30 days and pay that bill. And before you know it, they'll start extending. And now instead of $500, it'll be $750. It'll be $1,000. And as long as you're buying something and paying it within 30 days, that credit score will continue to climb because the banks need you,
Right.
because they make money off of the interest
Yeah.
rate. Okay, so they need people out there purchasing and utilizing credit cards. So it's going to happen. Okay, you're not done for the rest of your life. You will reestablish credit, and it will it'll now. Personally, I would advise getting a debit card. Okay, with the money that you used to pay your credit cards off with. If you need something, use a debit card.
Right.
Okay. I mean, really, what do we need credit? We need credit for a home, a car, maybe a large appliance purchase, and everything else. If you're patient enough, you can usually pay cash for it.
Yeah.
Okay. I mean, those are the things that you need, but everything else generally with a debit, and if you're, like I said, patient and build up that money that you used to pay in credit card payments and interest, leave it in the bank.
Yeah.
Before you know it, you're going to have a little pile there.
Yeah, definitely. Right. Good. Is that part of what those, you mentioned in Chapter 7, we have 2 classes that a client is required to take.
Correct.
Are they an hour long?
No, they're online, and
they give you some education.
Yeah, basically it's federal requirement. It's not brain surgery. But it has to be done. They hand you, and then once you get a certificate that's been completed, the company that you chose to take the course through will send me a certificate. We send it into the court, and it satisfies the requirement.
Do we take the same class for Chapter 13 or something similar?
There is a similar class.
Okay, and maybe we get that education on how to.
It's like how to manage, a checkbook and simple
Good.
stuff like that.
Good. Okay, so let's talk about Chapter 13.
Okay,
we've made some decent income. We're making more than the 40,000, and we're having this conversation with you. What's our option? Do we have 7? Do we do 13? You discuss that with us, and ultimately we decide 13 is the way to go. Okay.
Correct.
And we're again gonna fill out the same forms or similar forms.
We're filling out forms. We're getting
all of our listed
we're
debts.
getting income and debt information. We are getting now more specific information. All of your expenses. Okay. I mean, I need to know, HOA fees. All of your expenses,
school bills, kids' bills,
everything, and then we, say, okay, here's the plan. We send the plan to the bankruptcy Chapter 13 trustee to be approved. Okay, this is how we're going to address. We get to keep our stuff, but this is how we're going to address, getting through the 13. These are the payments that we can afford to make.
That's it.
Towards.
That's the key, right? It's really what
Correct.
can we
it's
afford
what you
to
can
pay.
afford to pay.
Yep.
That's exactly correct.
And we're having that conversation about the car payments. Do I keep the car and make them
right? And then and it may come down to, wait a second, you have 2 cars. You only have. Do you really need the second car? I mean,
Or the really, really nice car you're driving around, a BMW. Let's get that.
Well, they're not
going
to. They're not. I have not seen them come down on people that have higher value vehicles. I mean, you get to choose what you want. It's a matter of how much you're paying for it.
Okay. Yeah.
Okay. That's really where the issue comes down. I mean, you can
be in
a Yugo and be paying too much for it.
Good point.
So yeah.
Okay.
People don't even remember Yugos.
Yeah. Our time frames. 30, similar to the Chapter 7, 13. I know we got a 5-year time window to actually make all the payments.
All right.
But what do we look like for getting an approval from the magistrate to say, boom, here's your payments on all this?
That depends. But it's stated the petition is.
By the way, will you get rid of some of the credit cards? I mean, will it get rid of all the unsecured? It's just the secured
they're not.
stuff?
Yeah, because once we the chapter 13 trustee governs the distribution of the amounts to the creditors.
Right.
So the client individual sends the check to the trustee. The trustee then issues their checks to the various parties that have been approved by the plan.
Gotcha.
Okay.
In the plan, in Chapter 13, is there an option to say, I want to get rid of all the unsecured debt?
Well, okay.
Does that make sense?
Well, yes. What you can do, depending on the circumstances, sometimes we have to start with the Chapter 13 for whatever reason, and then circumstances change. Let's say you were making that good money, and now all of a sudden you lost a job or had to take one paying less, and now I can't meet the obligation that I agreed to in the 13, but now I qualify for a Chapter 7.
Okay.
We can convert the 13 to the 7. at that point.
Okay.
And sometimes that's the plan. Sometimes this to make the for what's best for the client, we'll start you in a 13, but once you reach this point, we're going to convert you to a 7, and off you go.
Yeah. What are those circumstances or point, as you say, that the trustee is going to approve moving from the 13 to 7?
Well, again, when you qualify, I mean, we will move. It's the burden of the consumer or me as your attorney to say, okay, what we're moving. It's a pleading. Okay, it's formal paperwork with the court to ask for a conversion from the 13 to a 7, and if you qualify with the same criteria that that we've already discussed, then you're in. Okay, and then the question comes, well, the stuff is usually the big issue. It's either the income or you had too much stuff. If it's income, well, that's clear cut, right? Then you qualify for a 7 because of your reduced income, and off you go. If it was something because you wanted to keep, well, if you sold it and that was the only hiccup, okay, well then that's different.
Yeah. Okay. Do we get a letter in Chapter 13 like we did in 7? 4 months later, you get a letter in the mail. It says, okay, Chapter 7, it's all done. Everything's been washed away here. Let's talk about 13. Is there a letter we're going to receive at some point?
You'll get a form that says to discharge, your case has been discharged. Now, I need to point out something.
If that's at the end of 5 years or something?
That's right.
Okay, well, what happened? Is there a 4-month window or something where we go, here's your payment plan. You write a check to the trustee for $5,000 or $2,000 or whatever that number is every month. When do you get that letter that says this is the amount to send to me? Is that,
well,
you follow me?
That's
right?
Before. Okay, you'll know that figure before the trustee knows that figure,
right?
Because we have sat down and we have looked at all the income and expenses and the obligations and said, okay, this is how much you can. We've mutually agreed. This is how much you can afford to pay. Then we submit that to the court for their approval. That has to be approved by the bankruptcy trustee.
Gotcha.
Okay, and once it's approved, then that'll be the game plan through the entire 5 years.
Is there a somewhat of a time frame about when I'll get that approval?
Well, it depends. But we can always, if for instance we send one out, and they don't like it, we can modify. We can amend.
Yeah, sure.
It's listen. They want. Here's the thing. This is not an adversarial proceeding. This is something where they want you to be approved.
Yeah, correct.
Okay. They want you to be. Guess what?
Yeah.
The trustee gets paid a percentage, so they want you to be in the program.
Yeah.
Okay.
Yeah.
And the chapter.
And something you can afford.
That's
something
right.
You can do on a
That's
monthly
right.
basis.
And they want you in the program. Chapter 7 trustees get paid a percentage of what they collect for the creditors.
Okay.
So they're looking at that's where their motivation is.
Yeah.
Okay.
Sure.
You need to understand that.
Yeah.
But they want you through the process. Okay. And it's non-adversarial. You either hit the federal requirements or you don't.
Yeah. Okay. You're going to help walk us through what hits it and what doesn't, so you're going to make sure you qualify,
correct.
Right? Okay. Gotcha. Let's talk about a couple of those outliners that may be there, and you can maybe think of some more than I can, but what about the issue when I deal with medical bills? And,
discharge.
Okay.
Discharge.
In 7 and 13.
Correct. Gone.
Was there a day that medical bills weren't allowed to be discharged?
I'm not aware of it.
Okay, just wondering.
I'm not aware of it.
How about child support payments?
Now that has to be definitely calculated. Child support is definitely in the when you're calculating income. Mm-hmm. Okay.
I'm getting it from my spouse. Their ex-spouse is paying
exactly.
me.
That's part of that's part of the equation. Mm-hmm. And if you have to pay child support, it's part of the equation. So it definitely comes into play. Okay. I
know a big one now is student loans.
Boy, that's
the nemesis.
That's an interesting topic. Student loans is a really if you've been paying, if the state of student loans is in flux.
Okay.
it's the current administration is working hard by themselves to because Congress has not really jumped on board. Most of this done through executive action, is to get a lot of people relief on student loans. And I think the time is running up in April. If you have not modified your student loan and you have one, you need to do it because after, I believe, April, you're kind of, at least based on the current law, you may not be able to either reduce it or discharge it. Now,
explain what that means. Modify it.
Okay. All right. Well, you have
a payment.
Student loans, generally speaking, are not dischargeable in bankruptcy. Okay. Now, there have been cases that have allowed for the discharge of bankruptcy if, for instance, your income cannot and never will meet your student loan debt. Okay. Example: I get a degree in basket weaving, and that cost me $100,000 to get that degree in basket weaving from Where Are You University. Okay, two big things there: basket weaving and Where Are You University. And no matter what that degree says, it doesn't really gonna make you a lot more money as far as an income is concerned. Okay, but you still have that student loan debt. What do you do? Well, in that extreme circumstances, they have found it where they will discharge your through bankruptcy. Okay, there's a current program going on right now with the bankruptcy that if you have a student loan and you meet certain criteria, we send out a packet to the Department of Justice, they're the ones that are implementing the program in an effort to either reduce or eliminate your student loans through the bankruptcy process. Okay. Now, without using this bankruptcy process, there's currently some programs available, and I think it's going to become, well, it's a hot issue right now, and as I pointed out, the administration is working on it. But basically, if your income and and they are now acknowledging that not all degrees, even if it's the same degree, are worth the same. Okay. Yeah. I have a degree from economics from Yale that gives me a certain amount of income potential.
Right.
If I have the economics degree from Where Are You University, that has a different as to income potential. And so they're acknowledging that and taking that into consideration, whether this student loan should be modified and or discharged.
Okay. Excellent. So influx.
And I'm trying to stay on top of it, but this week,
how do you file for the modification, for example?
In the bankruptcy process?
Before that, you're saying, hey, before April.
Well, because you have to get online with some of the student loan, if you and from my understanding, the current status is if you got a degree and have done some public service, you've attempted to pay back some of your student loans, and you've utilized it through low income or public service jobs, police, teachers, etc., and those people may get some immediate relief because the program has been implemented by the government.
Right.
Now, if you're outside of those, if you haven't made any attempts to pay your student loans, or you're in a regular, I say regular, but a more conventional degree from a more conventional institution, you still may be subject to some relief through the bankruptcy process by submitting the various forms. It depends on your expenses and your and income.
Okay.
And I have currently one that I sent up. It's through a chapter. It's through what's called an adversarial process. Okay.
Okay.
It's in essence a lawsuit within the bankruptcy process.
Okay.
We're already in bankruptcy. Now I'm filing a lawsuit in the bankruptcy process against somebody. And somebody can do it to you, and you can do it to somebody else. For instance, if someone is alleging that your debt to them should not be discharged, let's say based on fraud,
Yeah.
okay, then they can file an adversarial proceeding against your bankruptcy from being discharged.
Okay.
Okay, and it's a lengthy and somewhat expensive process. Most people don't do it, but
Right.
there it is available. Now, this adversarial process regarding the student loans just became available within the last few months and is relatively new in how it is being implemented and what the Department of Justice is utilizing in determining if any or how much of your student debt will be discharged and or modified.
Okay. All right. Another outlier, if you can explain how it works with a home.
Okay.
I've got a home I'd like to stay in. I'd like to stay in it. It's expensive, and I've got all these other extra debts on top of it. What's it look like in Chapter 7? What's it look like in Chapter 13?
Okay. That's always a toughie. Okay.
Yeah.
And especially in Central Florida, because of the current state of rental homes and rent is very expensive, relatively speaking.
Right.
Excuse me, in this area. So, generally speaking, if you a lot of people that are, let's say, middle class or moderate to low income, they're not living in mansions on the beach or whatever.
Right.
And generally speaking, their mortgage, if they want to keep their house, they have to pay their mortgage. Now, if they are behind,
Right.
okay, and we go into bankruptcy, we can help them get caught up.
Okay.
Okay, I mean that's kind of part of the process. But if you're in debt and you have a home and you own the home, pay that before you pay your mortgage before you pay anything else.
Yeah.
Okay. Because if you have any because of the equity, they can't take it, and if you want to live there, and you're probably paying less in mortgage than you would for an apartment today.
Right.
Then you want to keep it, and so pay your mortgage. Don't pay other things, especially credit cards. I'm not, if you can't, but you got to pay
Paying
that
the
mortgage.
Macy's bill or the Target bill.
Yeah, I would advise, and I advise my clients once they have made the decision to file bankruptcy, stop paying your debt, your consumer credit cards. Stop it, because I'm discharging the debt. Why are you paying now? So use that money for some other thing. Okay.
So you're able to discuss the home situation with somebody that's a potential client and what
Sure.
they're looking at their payments versus a rent, or if they sold the home,
And
took out the equity.
Right.
So the creditor, the trustee isn't going to go, hey, you've got $50,000. You only owe $100,000 on that home, and you have $150,000. You need to spend that $50,000 to pay
Nope.
all these guys.
Can't get it.
What's up?
They can't get it.
Okay.
And they're not going to ask anyhow because they know they can't get it.
Okay.
And the only time they, is if, it's never occurred to me where someone had more equity than I could protect.
Yeah.
And that has yet to happen to me. Knock on wood there. One of the other factors regarding homeownership is HOA fees.
Yeah.
A lot of time people will be paying their mortgage and then get delinquent in their HOA fees, and then the HOA wants to foreclose. Okay, well, we can stop that. And your past due HOA fees get discharged in the bankruptcy. Okay. Now, the payment after the petition date, you got to pay that.
Yeah.
If you want to keep the house, but before the petition date, we can get rid of that.
Is that right? Okay. I was trying to think of one more. Oh, I know one. Whenever I've dealt with a client who's going through a current bankruptcy, and it might be a 13, it might be a 7. What if they received income in a settlement from an accident, from their slip and fall, a car accident? How does that come? How's the trustee look at that?
It
Does
depends.
all income have
It
to come
depends
to-
on pre
Okay.
or post petition.
Okay. Let's say They petitioned.
Post-petition.
Post-petition.
Post-petition, it's theirs.
Okay. They have to get approval from the trustee to accept it. They have to tell them when extra incomes come in. They hit the
well in
lottery
a 13, if they're if a big lump sum comes in, that may become a factor.
Okay.
But generally speaking, and it's compensation, it's not income. So that's one factor. But the more common element is when you pre-petition.
Mm-hmm.
And believe me,
they had an accident in 2023, and now they've come to you next week and say, I need to file, and you do the petition. So we're pre-petition accident.
Correct.
Right? Okay, now what
Correct.
happened?
Now
they settle it in 2025.
They're not necessarily going to be able to settle that without going through the approval of the bankruptcy court. Okay. What happens is if you have a pre-petition automobile accident that's in process of being through the process, whether it's pre-suit or in suit, you will not take the proceeds of that unless I can protect it. And chances are I can't. Chances are the income that is going to come, or the compensation that is going to come from a settlement, probably is not going to be able to be protected. And every trustee, a bankruptcy trustee, when I talked about that meeting of creditors, and they ask you questions about the petition, well, one of the questions they ask that's not on the petition: have you been in an accident, or is anything pending, or are you going to inherit anything? That's another one that comes up. Okay, they're looking. Okay?
Yeah.
And if there's, I was in an accident. Well,
I was in an accident 6 months ago.
6 months ago. Well, what's going on?
I'm in the middle of the case.
Do you have an attorney? And they want to know, and boom, the trustee will immediately send off notification, generally speaking, to the attorney, indicating that they need
keep me updated.
Because guess what?
Right.
And this is trust me, I know this is is that you are no longer, once the petition is filed, if you had remember I said all contracts are null and void?
Yeah.
So is your contract.
Is that right? The attorney-client contract.
Your attorney with your PI attorney, that agreement for compensation for representation is null and void. And now what will generally happens is that the trustee will contact the attorney and reestablish an agreement. They'll let you keep the case, but your fees may be affected.
Okay.
And certainly the results that go to or would go to the client. So in essence, you lose control of the file.
Okay. The client does.
Yes.
Because they're not going to get those.
They're not going to. They're not going to get the
Wow.
proceeds of the. So in essence, if you can hold out, I would do so. And
what does that mean? Hold out.
Well, if you can hold out from petitioning for bankruptcy,
gotcha.
to settle your PI claim, and then properly dispose of the proceeds from the PI claim in a way that they can't get it. Come see me, and I'll tell you how to do that.
Okay. What about the event occurred after?
Now,
the
a post petition. Again, it's and again, Chapter 7. No factor whatsoever. It's yours. And in a 13, the lump sum could affect the amount distributed to the creditors.
Okay. So the trustee gets contacted in the Chapter 13.
If
post-petition.
Depending on, correct. That is correct. Because we are under legal obligation if circumstances change to modify the 13 agreement if circumstances dictate.
Got it.
Basically, if I know.
Yeah, sure. Well, good, man. You covered a lot. That's really good education, man.
There's a lot to it.
Yeah.
There's a lot of nuances, and one of the reasons I love doing it is because, generally speaking, you're immediately helping somebody. You're immediately getting satisfaction that you are helping them out, and people in debt. And I again, it's just stuff, ladies and gentlemen, and what's more important is your health. And people stress out, and that'll get you sick. Okay, if you're constantly worrying about your bills, and it affects marriages, it affects everything.
Sure.
Your quality of life.
Yeah.
Okay. This is a way to get back your quality of life, and I really believe that because I've seen
peace of mind.
I have seen it.
Yeah. Yeah.
I've seen it.
Well, you see the stress and what it does to
Oh,
families.
absolutely.
And the big issue with separation of families being so significantly impacted based on finances.
Absolutely.
Yeah.
Absolutely. You ask any domestic attorney will tell you that is a major factor.
Yeah.
In what
Right.
probably happened to a once thriving relationship.
Yeah. We won't get into it because I know it's going to be a longer discussion. Have we covered the personal areas of bankruptcy, or are there other options of 7, 13?
Well, there's business bankruptcy.
That's what I was going to say.
Which I do not. I don't do business bankruptcy.
A whole nother area.
It's
right?
a whole
Another
separate
monster.
beast.
Yeah. Okay.
In itself, it can, and generally speaking, it gets a little complicated when people are self-employed, going through Chapter 7 process.
Yeah.
Okay.
Sure.
And this is where I told you that sometimes we have to wait to delay. The bankruptcy trustee, with the information we provide them, generally goes back 6 months, and that means they want your bank statements for the previous 6 months, etc. Right. However, if there's an issue, they can go up to 2 years in the past into your bank statements.
Wow.
If they suspect something fishy.
Yeah.
Okay. And believe me, they have seen it. They know what they're doing.
Yeah.
And we're not going to give them any reason to want to, to do that. If you're upfront and give them what they're entitled to, and they want to have. It's not adversarial. They want you to go through the process.
Yeah. So, best way to reach you?
At my phone, which I'll be honest with you, I can't even think of it right off the top of my head. It's nardyandnardy.com, and you will see the phone number and the contact number, we will set up something at the earliest convenience to make it happen, or not make it happen. Sometimes you just need the information.
Yeah.
Sometimes I can provide
that consultation.
Free consultation, and this is where the attorney and counselor part comes in.
Right.
Where you can give some good advice sometimes because, people are so locked into their box they can't see outside of it.
Right.
And sometimes we can help you see outside the box.
Yeah. Or may have some misinformation.
Or even and again, sometimes if you look at things in advance and give me the opportunity to plan, the more stuff we can save and more I can protect through the process.
Good.
If you're up against the wall, you wait until you're totally up against the wall. Well, we'll do the best we can, but it would have been better if you would have let us know a few months ahead of time.
Yeah.
That can happen too.
Yeah, sure. Well, Perry, I appreciate your time. I know it's valuable, and you've given us some really good information. We know we can go to nardy, NARDI.com. That's how we spell it, and we can get your information. What's the payment process? I know your time is valuable, and clients have to pay you for this. What's a range of what expenses are for a 7 versus a 13? What's that?
Well, the expenses are relatively. You have federal filing fee, which is. You're filing. It's not like a pre-suit PI case. You have to file.
Sure.
So it's a $400 federal filing.
Good.
Okay. And then you have the 2 online courses, which cost about $20.
Okay, that's good.
Each one, maybe.
Right, we're under 500.
And then there's the attorney fee.
Okay.
Okay. And the only hiccup generally with the bankruptcy attorneys is that you have to be paid up front, otherwise you become a creditor, and that screws things up.
Sure.
And then they will take your fee to pay the other creditors, which generally attorneys don't care for that.
No, exactly right. Help to the process. Great. Well,
now, chapter 13 is more expensive than Chapter 7. Again, it's a 5-year. Not only does it require a much more entailed evaluation and processing the information, but we also monitor the entire process during the entire length of it. So if something comes up, we're still representing you.
Yeah.
Okay.
Right.
So in year 4, if something comes up, whatever it may be, we still represent you and have to fix it, whatever that is.
Yeah.
Now, I also would point out, I mean, one of the hiccups in a 13 is if for whatever reason you can't make the payments or don't make payments, and there are varied amount of reasons, but it's possible that if you get kicked out of a 13, you're back at square one, and you owe all that debt, even though you paid all that money. Yeah. Okay, so it's nothing. You know, once you go through a 13, you stick with it and make sure it's part of you're going to pay your DNA exactly, because you got to get through that. Yeah. You don't want to get kicked back.
Right. Yeah. Sure.
And usually they don't want you to get kicked back, so they will, if there's something that comes up, usually if
try to work around it,
they'll try to work around it. You know, maybe you were out of work for a month or whatever, we can work around that. Yeah. Okay. That's generally and that's why we have to hang in there for the 5 months. Things happen. Life happens to people. You know, circumstances occur, and everybody's aware of it. So let's work through it instead of making it a problem. Let's find a solution.
Yeah. Well, excellent. Thank you for your time, Perry.
It's been my pleasure.
You so much.
My pleasure.
As we conclude here, I'll just tell you, great information. Get a hold of Perry. Get on his website. Contact him and his assistant. They'll get you started if this is an option for you. Any other questions you have, of course, you can reach my office at hogansmith.com, and our phone number 1-800-514-6426, and we'll get you over to Perry and help him get that contact with you to get started, okay? So thanks for your time. We look forward to seeing you next time here on the podcast.
Thank you.
Excellent, brother. Yeah.